We might need some more chairs. Good afternoon, everybody. I'd like to go ahead and get started. Welcome to our CLE presentation today, which is on tribal sovereignty and tribal courts. Before I introduce our speakers, I just want to make a plug for the exhibit called Why Treaties Matter that is coming to the State Law Library next week. We'll be having a kickoff at noon in this room on Friday. And so I encourage you to come over and check out the exhibit. It's very, very well done. Our two speakers today are both from the Jacobson Law Group. We have Joseph Halloran over here, and he is a graduate of William Mitchell College of Law. Joe represents tribes in a broad array of matters. He's also served as in-house general counsel and is a qualified neutral mediator and arbitrator under Rule 114. Throughout his career, Joe has represented tribal gaming regulatory authorities in all aspects of gaming regulation. He has taught Indian law at William Mitchell and has presented and lectured at numerous CLE courses, and he is a special member of the Minnesota Indian Bar Association. In addition, we have Michael Murphy, who is also a graduate of William Mitchell. He joined the Jacobson Law Group in 2014 after serving as a public defender for the Regional Native Public Defense Corporation in northern Minnesota. Prior to his public defense work, Michael served as the 2012-2013 Fulbright Scholar in Law to Papua New Guinea and consulted for the World Bank's International Finance Corporation. He is also a qualified neutral under 114, and he continues to work in ADR in Indian country with the Jacobson Law Group. So please help me welcome them.
Thanks, everybody. Joe Halloran. I'll be handling the first part of what will be a two-part presentation. The second part will be handled by a taller, smarter, better-looking version of me, Michael. And out of the gate, I want to apologize to you. This presentation covers a pretty complex topic. It sounds simple enough, but it really is a topic, just tribal court jurisdiction, that an entire law school semester class would cover. And typically, that class would be taken by a student who had already taken a semester-long course on some of the basics, the Indian Law 101 basics that I will be providing as an overview as well. So this is going to cover roughly 2 semesters of law school in an hour. And so I apologize for that. If it seems a bit summary, that's because it is. And I also want to note that we have attempted in the past to have questions at the end of the presentation, and, you know, like the best laid plans of mice and men, that has always gone awry. And so what I ask you to do is, if you have a question, to just stop me and ask me during the presentation. I think it's more likely that we'll be able to get to it that way than to save questions for the end. So I'm going to talk to you generally about the context for tribal jurisdiction in Indian country, tribal court jurisdiction. When I started practicing 20-some years ago, tribal courts in the state of Minnesota were very new. And over the couple of decades of my practice, I've had the benefit of being able to watch these institutions develop and grow to a point now where I know that we have experience in the room where tribal courts are engaged in interjurisdictional work with the state system. And I think that the development of that seamless delivery of judicial services in Indian country has been a real important benefit to the state as a whole as a result of tribes being able to build their own institutions and their own tribal courts. I was recently up north visiting the Leech Lake Band, and they have a very active interjurisdictional engagement with Cass County. I believe they may be starting one with Itasca County on health and wellness court. Courts are picking up tribal courts are picking up domestic violence jurisdiction, developing codes, and those matters as well will necessarily result in the interrelationship and articulation of tribal courts and state courts in the state of Minnesota. In order to get to the discussion of what is that jurisdiction for tribal courts in the state of Minnesota, and why is it that we're dealing with the issues that we have as between the two sovereigns, the state and the tribe, requires that we go through some sort of basic concepts, if you'll bear with me, to get an idea of what a tribe is, what the nature of its authority is, and how it has had its jurisdiction or its sovereignty limited in some ways, and how it has addressed that. So with that, this is our overview of the presentation. Michael will talk about actually working in the courts of the 11 federally recognized Indian tribes, and then provide some practical practice pointers for those of you who are or may be interested in practicing before the tribal courts in the state of Minnesota. So this is Felix Cohen. Essentially, I'm echoing Cohen on his idea of his notion that it's important in Indian law to understand the context, the history, and the policies that influence tribes and shape the nature of its jurisdiction. Glad that I agree with Professor Cohen in that regard. So the United States is unique in that it is the only country in the world where the country's indigenous people have a domestic sovereign status. There's no other experience like that in the world. It's not true in Australia, it's not true in Canada, it's not true in other countries where there is a historic indigenous population. And the reason for that really, in summary, is that in the very pre-constitutional relationship between tribes and what became the government of the United States, tribes were not just commercial partners, but more important, they were significant, had control over significant portions of land, much of which sat on the rear flank of the new forming country. And they were also considerable military powers. And so there's a real interest in the framers to make sure that relations with the tribes was centralized. And so that's why you see that relationship cemented in the Constitution as being a federal relationship. There are real practical interests for that. One is a military interest. The federal government wanted to control military alliances with tribes as an international military strategy, with the French and the British nearby, but also to control the military relationships with tribes that some of the colonies might form. You know, we're trying to hold together what hadn't quite formed into a fully coalesced union yet, and the interest of the federal government was to make sure that any military alliances were with the federal government only. There also was a real interest in controlling how the land would be handled if it were ceded, if tribal lands were entered. The federal government was interested in centralizing the role of dealing with indigenous people's lands rather than allowing that to be dealt with by the colonies. So you'll see that in the Constitution that commerce and really military relations are cemented in Article 1, Section 8. And that really informed, moving forward, the building of that federal tribal relationship. And I think it's really important as we talk here at the State Judicial Center to explain what the context was for states not having a role, and the presumption that is developed in the law that states are presumed not to have jurisdiction in Indian country or over Indian affairs unless that authority has been delegated by the federal government. It has a constitutional basis, and it had a historical federal self-interested purpose for cementing that relationship in the Constitution. So what you'll see coming out of the early trilogy of the United States Supreme Court, in the Marshall trilogy, and then in subsequent decisions, is a fleshing out of what that federal-tribal relationship means, both in type, where that relationship is a government-to-government relationship that predated the Constitution and was simply confirmed in the Constitution. And later in Williams v. Lee, you see a development of what does that mean from a tribal perspective, and what that really means is the right to self-determination for tribes over their territory and their people. In addition, the Supreme Court speaks to the fact that tribal powers, as predating the Constitution, are inherent powers. And I think that's an important issue to keep in mind when looking at the exercise of tribal jurisdiction. Tribal governmental authority is not delegated. It's not statutory. It is inherent. And so that implicates how that authority can be limited and by whom. And the early Supreme Court decisions make clear that the domestic sovereignty of tribes is an inherent power that has never been extinguished. And with that, in Santa Clara Pueblo, the Masery decision, and especially U.S. v. Montana, which I'll speak to in a little bit, it's important to keep in mind that that inherent sovereignty has limitations. And the principal limitation of tribal sovereignty is that it is subordinate to the superior sovereign, to the federal government. And the federal government can delegate jurisdiction to states to exercise in Indian country. It can limit the sovereign nature of the tribal governmental authority. And it can also determine an absence of jurisdiction over, for example, as we'll see, non-members in the criminal context. So the early Supreme Court decisions really sort of brought a bit of body to the skeleton of that federal-tribal relationship that you see in the United States Constitution. And I think the important takeaway is inherent sovereignty. It's a right of self-determination to make your own laws and be governed by them in your territory and as to your people. And that authority is ultimately subservient to the federal sovereign, but not to the states. There are several limitations, further limitations on sovereign authority, and I refer to those as a limitation that a domestic sovereign has, that it can't engage in external activities. It can't exert externally its sovereignty. So you'll see limitations in the conduct of foreign relations. There was a very good reason that decision came out in 1832. There's a concern about military alliances, tribal military alliances. There is a limitation on tribes' ability to alienate trust lands. And I don't want to get into land tenure in Indian country, which I love dearly, but you would all fall asleep. And that is principally because trust land held by the United States for tribes is held, the legal title is held by the United States. And the beneficial title is held by tribes. And so a tribe's ability to alienate land to which it doesn't hold the legal title is non-existent. We'll also see the exercise of criminal jurisdiction over non-Indians came out of the Oliphant decision, Justice Rehnquist's decision in 1978. And the exercise, this is the real sort of the key one that I'm going to focus on in the later part of this first part of the presentation. The exercise of jurisdiction, civil jurisdiction over non-Indian activities on fee lands within the reservation. And here's the key: absent some consensual relationship or some direct effect on tribal health, welfare, political integrity, or economic security. Montana v. United States is commonly, that formulation is commonly referred to as the Montana test, and the Montana test typically is considered to have two parts. One, a consensual relationship, or two, having a direct effect on tribal health, welfare, political integrity, or economic security. There could be both. As to sort of tie this all together, at the end I'll speak to the Dollar General case, which is now pending before the United States Supreme Court, which goes directly to what the Montana decision means, and it is the most, I think it is going to be the case with the most direct impact on the Montana two-part test that has occurred in the last 35 years. Tribal sovereign powers. I'm not really here to talk about sovereign immunity. One of the powers of a tribe, of course, a domestic dependent sovereign, is immunity from unconsented suit, and that immunity exists absent a waiver by the tribe or an abrogation by Congress. Immunity is often waived by contract in business transactions. Sometimes tribes will adopt ordinances that provide a waiver for enforcement, for example, the Tribal Tort Claims Act, something like that. But absent a waiver or abrogation, immunity exists from unconsented suit, and that is the right not to be hauled into court. It's not a defense. It's a jurisdictional threshold. And that immunity exists unless waived or abrogated, and that immunity extends to the jurisdiction of federal courts, state courts, and tribal courts. It's not often realized by practitioners that immunity is to tribal court jurisdiction as well, unless there is a waiver. Some folks think that it's an immunity to foreign jurisdictions, but not to the tribal court. But immunity does extend to tribal court jurisdiction. So we'll speak to civil jurisdiction, criminal jurisdiction, and then what I'd really like to talk to you about in the state of Minnesota, I think particularly relevant, is the impact of Public Law 280. Now, before we move forward, I gave you a little bit of the constitutional tenet and then the early Supreme Court decisions. I think the other thing that is necessary as a backdrop to this analysis is an understanding of the changing in federal Indian policy periods. And I'll give you a very brief overview because it explains why, for example, you have a reservation in Minnesota. How did the name come up? And why are there a whole bunch of non-Indians that live within that reservation? And what does that mean to the jurisdiction of the tribe? So the first period of federal Indian policy, really from as the colonies were developed and began, and expansion began moving east of the Appalachians, was a period of removal. And the basic idea was remove the Indians to the west. In Joseph Ellis's book, His Excellency, about George Washington, it's interesting that he noted from Washington's papers that one of Washington's greatest regrets in his second administration was that he hadn't provided a permanent solution to the Indian Territory. It simply was an ad hoc policy of moving the tribes that were in the way to areas further west. That removal policy, really, I refer to the late part of the removal policy as being more of a contraction policy. So once you get immigration west, the rails are promoting settlement. Territories are wanting to become states. There's a federal interest in getting states into the Union for political purposes in DC. There was enormous pressure, and the United States essentially ran out of west for the Indians. So you'll see a lot of the later treaties in the 40s, 1840s, 50s, 60s, 70s that are contraction treaties. They are cession treaties, land cession treaties, but they aren't a removal, they are a contraction. So for example, in Minnesota, let's just take for example, the Chippewa of the Lake Superior through the 1854 treaty ceded millions of acres, and then in the treaty reserved for themselves, didn't cede, lands that would be identified and held as their permanent undisturbed homeland. And so the Bois Forte Band has reservations up near the Canadian border. The Grand Portage Band has a reservation near the end of the Arrowhead. and the Fond du Lac Band down at the base of Lake Superior, Fond du Lac, bottom of the lake. Likewise, the Dakota in the south, through the 1851 treaties, Traverse de Sioux and Mendota, ceded 24 million acres to the United States and reserved for themselves an undisturbed homeland. And in the 51 treaty, the undisturbed homeland was to be a strip of land on both sides of the Minnesota River that runs from roughly Morton up into Yellow Medicine County. 7 years later, the Senate got around to ratifying that Constitution and decided they didn't like the northern piece of the reservation, and so the Dakota were left with a reservation just on the south bank of the Minnesota River. The point being is that these lands they're called reservations because they were reserved in a treaty that's otherwise focused on land cession. So we ran out of room, now we're ceding land. Following the treaty period, there continued to be enormous pressure. In Minnesota, there was enormous pressure for the timber resources, and in the southern part of the state, there was enormous pressure for homesteading and farming. Huge numbers of settlers coming into the area, lots of Swedes and Norwegians in the north that were lumbering, and an equal number mixed with some Germans in the south who were farming. This pressure was true all over the United States, where tribes had reserved these undisturbed homelands. And what you will see is that these areas, I think the principal example would be the state of Oklahoma. The state of Oklahoma was originally to be the state of Sequoia, and it was to be a consolidation area for all of the removed tribes that didn't have a reservation. Oklahoma was then opened up to settlement and the land was allotted, and the state of Sequoia was then reduced to smaller reservations, and those were in turn allotted. So the next policy period I'm speaking of is the allotment and assimilation period, where the federal government under pressure, wanted to get access to these reservation lands and resources, and similarly they wanted to end tribalism, viewing that as tribalism as one of the greatest impediments to what they viewed as the need to civilize tribal people. So allotment and assimilation went hand in hand, and what allotment provided was that tribal members would be patented a trust allotment of 80 acres, roughly, sometimes more, usually 80 acres. And those lands could be used for farming, and there would be implements provided. And it also had an educational and a religious component, so the real goal was to turn tribal members into good Norwegian farmers or lumber people. So the tribal members took allotments, and then the land that was left was opened up for non-Indian entry. And that happened for several decades. Timber companies, homesteaders, just settlers came in and were taking land that was available in the public domain because the allotments had been taken and the rest of the land within those reservations was opened up for settlement. When that finally ended and the next period of federal Indian reorganization occurred, the result was what's often called a checkerboard land tenure in Indian country. So if you look at the Leech Lake Reservation, I think some 105,000 acres, I believe, it is shot through with non-tribal fee land. Same thing happened in White Earth and in other Chippewa tribes, and really across the country. It's important because when the tribes reorganized under 34, the new policy was, well, allotment and assimilation didn't work. We didn't civilize tribal folks. They're holding on to their tribalism. They're just a lot more impoverished than they were before. And reorganization was designed to provide them a basis for reorganizing their governments and providing services to their people and restructuring their lives. And a large part of it was to reacquire their lost land base. That has been only partially successful. Tribes are left now with on-reservation fee lands that they acquire at market rate that they lost for nothing. So in any event, the reality after reorganization was this mix of tribal and non-tribal land ownership in Indian country. So the next period, we're currently in the current period of federal Indian policy was ushered in by the Nixon administration, the period of federal policy of Indian self-determination. And that was designed to encourage as much as possible, 5 minutes really. Okay. Okay. Don't ask any questions, no. So you will probably meet and eventually get to know a number of tribal people who are Republican, and without saying anything about politics, you wonder why that might be. It's because Richard Nixon had a very insightful, progressive federal Indian policy, which was designed to encourage tribes to work with the federal government to deliver their own services, to decentralize services to Indian country, and to really develop their self-determination. The policy period that is really relevant to Minnesota precedes that. So after Indian reorganization, for about a 10 or 15 year period in the 50s, the federal government ushered in the termination policy era. Sounds ominous, and it was. The design was to terminate tribes, to take their assets and divide them up among the members like a distribution to shareholders from a dissolved corporation or partnership. And some tribes, notably nearby, the Menominee tribe was terminated and then later restored. So the point is with these policies is that when you're practicing in Indian law and you're looking at jurisdiction, you have policy whiplash such that you probably need a chiropractor. But more importantly is a lot of those policies are reflected in laws that are still on the books. And so it really is complex to be in a self-determination era and attempting to harmonize an allotment period statute or a termination period statute. So it's important to recognize that despite the change in policy periods, the policies as implemented in statutes largely are still on the books. They haven't gone away, and they inform how you look at jurisdiction and how that plays out. I want to give you an example. I'm going to hop ahead here because I'm running out of time. Public Law 280. I mean, you don't really talk about a tribe in Minnesota as a lawyer or a judge with Public Law 280 doesn't come up. Public Law 280 was a termination policy statute that was designed to address a lack of law enforcement in Indian country. It was a vacuum for law enforcement and available forums for dispute resolution. And the idea was to extend state criminal jurisdiction through the county instrumentalities to Indian country. And that happened. Minnesota was a mandatory Public Law 280 state. There are 2 tribes in Minnesota that are not subject to Public Law 280. The Red Lake Nation never was subject to Public Law 280 through their efforts in intergovernmental relations. And the Boys Fort Band of Chippewa was initially subject to Public Law 280, but were able to retrocede that jurisdiction, secure a retrocession of that state jurisdiction back to the feds. So in Public Law 280, you have state criminal jurisdiction that extends to Indian country. In a non-280 reservation, criminal jurisdiction is a combination of tribal and federal criminal jurisdiction. Public Law 280, I think the other thing to keep in mind, 2 things to keep in mind really about Public Law 280. One is that the extension of criminal jurisdiction to Indian country did not diminish or abrogate the tribe's inherent criminal jurisdiction. It exists. A lot of tribes didn't exercise that jurisdiction because it had been picked up by the state, but it did not abrogate tribal criminal jurisdiction. And you will see a number of tribes on 280 reservations who now have the resources and are developing and enhancing their tribal criminal codes, especially as they relate to domestic violence on the reservation, but really on a broad array of criminal enforcement, subject to the Indian Civil Rights Act, which I'll speak to. The second thing to keep in mind is that Public Law 280 did not affect an extension of civil jurisdiction into Indian country. It was not a grant of civil jurisdiction, and the case that really stands for that proposition came out of Minnesota. The seminal decision on Public Law 280 is Bryan versus Itasca County. Russell Bryan had a trailer in Itasca County at a time when Minnesota still had a personal property tax. And Itasca County assessed a tax on his trailer. He didn't think that was right, so he went to a legal aid lawyer known as Bernie Becker, who became United States magistrate. And Bernie was something else, big guy, smoke a cigar, Chicago guy, brilliant legal aid guy. So Bernie took the case on the theory that state tax law was civil in nature and that Public Law 280 did not extend that jurisdiction to Indian country. He lost 7-0 in the Minnesota Supreme Court. And undeterred, appealed the case to the U.S. Supreme Court and won 9-0. And so that template that you see the Court of Appeals and the Supreme Court in the state of Minnesota and Stone and Jackson and some of those cases wrestle with is, where is that line that was established by Bryan between what is civil and what is criminal? For example, driving without insurance, or DUI, or is DUI a regulated conduct that's part of the larger permitted conduct of driving and so civil, or is it criminally prohibited and so state would have jurisdiction? And Minnesota Supreme Court in a series of cases tried to draw a line as to the distinction between civil jurisdiction being asserted by the state and criminal jurisdiction. Prior to that, the Bryan versus Itasca County decision it really still forms the legal analysis template for jurisdiction in Indian country, civil versus criminal. And it led directly to and was the template for the Supreme Court's decision in California versus Cabazon Band of Mission Indians. Cabazon Band was operating high stakes bingo. I believe as Riverside County came to shut them down, and the band challenged the enforcement action, saying that the state generally permitted gambling and regulated it, and therefore the laws regarding high stakes bingo or restricting high stakes bingo was a regulatory law that didn't extend to Indian country. Went up to the United States Supreme Court, and applying the template that came out of the Bryan case, the Supreme Court determined that the gambling laws in the state of California were regulatory in nature. And that's why you have casinos in Indian country. It wasn't a gift, a monopoly gift. It wasn't a delegation of some ability to do something. It was a result of the Supreme Court interpreting whether state law could overcome or infringe on the inherent authority of the tribe. And it concluded that in that instance, that those laws were civil in nature and so did not extend to Indian country in order to preclude the high stakes bingo operation. I do want to move forward on the Montana case and Dollar General. The Montana decision set up a test in Indian country, civil jurisdiction over non-members. The really fundamental question is, when you have these people who are residing in a reservation, they're on fee land within a reservation, or they're engaged in business on a reservation, what is the scope of a tribe's jurisdiction over those people? And the Montana decision established the two-part test. Is there a consensual relationship with the non-member, or does the conduct threaten the health, safety, or welfare of the tribe such that the tribe has a heightened police interest, a police power interest in asserting jurisdiction? Two cases that have come up since that I think are interesting is A1 Contractors versus Strait, which came up out of the 8th Circuit on the Fort Berthold Reservation. A1 Contractors was providing contracting services on the reservation, and they were driving down the highway and got in a car accident and injured Patty Fredericks, who was a non-Indian spouse of a tribal member. The tort claim was brought in 3 affiliated tribes tribal court. Jurisdiction was found, and the jurisdiction was reviewed. Now, an exercise of tribal jurisdiction over a non-member is reviewable in federal court. It is, because it raises a federal question. So federal question jurisdiction is available for the federal courts to review a tribal court exercise of jurisdiction over a non-Indian. And in that context, the case went up to the Supreme Court, and the Supreme Court determined that the tribe did not have jurisdiction over the tort action. And the reason that Justice Ginsburg, it goes to show you that Indian law issues are not left or right. Justice Ginsburg wrote what I thought was a terrible Indian law decision, that the tribe didn't have jurisdiction because the accident occurred on a federal right-of-way, highway right-of-way, and so was not Indian country. Now, if you look at the definition of Indian country in 1151, it includes rights-of-way, but there's no appeal from the Supreme Court, so that was the decision. Subsequent cases have fed on language out of the A1 Contractors case that a tribe's adjudicatory authority cannot exceed its legislative authority. And in the Dollar General case, that has really been put full force in front of the Supreme Court. Dollar General operates I think they still operate, a store on the Choctaw Reservation in Mississippi, pursuant to a tribal land lease. And the tribe had a youth opportunity program where it would send kids to be mentored for free. And during the mentorship of one of the kids, he was sexually assaulted by a manager of Dollar General. Tort claim action is brought in tribal court. The tribal court finds jurisdiction. Review jurisdiction is sought in federal court. The federal court affirms the jurisdiction under Montana consensual relationship test. The 5th Circuit of all circuits finds jurisdiction under Montana. You think you're all right with that kind of a track record. A petition for cert was filed and granted, and the Supreme Court heard oral argument on the case December 7th. Now it's interesting because the petitioners before the court are seizing on A1 Contractors to suggest that the consensual, two things really, that the tort claim is not related to the consensual relationship. The consensual relationship was to run a business, and the tort claim was a significantly outside, unexpected conduct that takes it outside of the jurisdiction that can be asserted under consensual relationship. Are you tracking with me? And secondly, they're arguing based on the A1 Contractors language, seizing on that language to suggest that where the Supreme Court has been going since A1 Contractors is that tribes' adjudicative authority is as limited as its legislative authority, and if the tribe can't legislate to affect the rights of a non-member, it can't adjudicate to affect the rights of a non-member, essentially arguing to the United States Supreme Court that there is no circumstance in which a tribal court can assert jurisdiction over a non-member for conduct on the reservation. A significant play on Montana. Not really sure where that's going to go, but I wanted to raise that. So we expect a decision out, I don't know, maybe late April, June. If you're interested in the development of where Montana is going and what it means for tribal court jurisdiction over non-members, you're going to have the seminal decision coming out in the next several months. I apologize, there's a lot of content that I wanted to cover with you. I got through about half of it, but I do want to give some time to Michael, and I'm available to you all for questions or comments. Yes.
Well, thank you, Joe. Give me a little spell. Joe's the boss, so I get as much time as I'm afforded. So I really appreciate the opportunity. What time is it?
It's 20 to 1.
It's 20 to 1. Oh, we got plenty of time. So I want to focus, drill in a little bit and really just focus on the tribal courts as an institution, a central role that tribal courts play within their own communities, but also, given the audience, the state as well, and the state counterparts that they are working closely with. You know, I'll start with a general proposition that I don't think it's not anything remarkable, but any court's legitimacy is derived from the confidence of the people that it serves. And that's with this backdrop that we've just heard, coming out of this backdrop and the complexities of it. We have tribal courts in their contemporary form establishing themselves and serving a discrete community. And so we have these quotes up here, of course, that sovereignty begins at home. It begins within the community, and the members, tribal members that are availing their rights within their own forum. And the tribal court is such an essential expression of tribal sovereignty, and it plays such a central role in guarding what sovereignty means to the people and what that expression is. But of course, tribal courts exist and operate in a larger ecology and in a larger ecosystem of judicial systems, and are serving people beyond just their members, including non-members. What we have here is a tribal court decision being interpreted by the Supreme Court, a tribal court decision that has defined the contours of its jurisdiction in relationship with the other judicial systems that they're operating with, defining the contours of their authority. So I want to just emphasize that tribal courts play a very critical role in relationship to the state counterparts, but also emphasize that in many circumstances, tribal courts are best situated to determine the complexities of the law that Joe has just described, as well as determining the contours of their authority in relation to the state. So we'll move forward here. This is broad overview here. I'm going to try to go quickly. Just quickly describe the tribal courts that are operating here in Minnesota, and then really drill into what they do. I want to give you guys a snapshot of the robust practice and substantive areas of law that tribal courts are hearing, seeing, deciding the conflicts that they're resolving every day. And then if we have time, get into some practical pointers for folks that would appear before tribal courts. So this is a map of the treaty secessions and dates, and it gives you a picture of Minnesota and the time periods which different tribes had ceded large swaths of territory under these treaties to the United States. And this is the reservations that are now currently comprised tribal territories in a contemporary context. And like Joe had said, these blocks of black don't really represent the reality of the situation. Those are the boundaries of the reservation, but because of the allotment period, those are shot through with different types of land, and that affects the kind of jurisdictional, the contours of the tribe's jurisdiction within. So White Earth, Leech Lake are, what would they say, checkerboarded and allotted, and so there are many different types of citizens living within those areas, non-tribal members, non-Indians, and then tribal members, of course.
Mike, can I mention something about the Sioux communities?
Yeah.
If you go back and you take a look, you might wonder, you see these large boxes up north with the Chippewa communities, and then you see these dots with the Sioux communities. And the Dakota range historically was much further north, and when the Chippewa came into Minnesota, there was conflict between the tribes for many, many years. One of the things that the 51 Treaty did was establish essentially a separation. But the reason you don't see a defined reservation areas is a direct result of the Dakota War of 1862. There were two statutes that were passed following the Dakota War, one on February 16th, one on April 3rd of 1863, what am I trying to say, abolished the Dakota reserves and sold and returned the land to the public domain for sale, and the second of which was to banish the Dakota from the state of Minnesota. So that following 1863, if you saw a Dakota person in the state of Minnesota, you could shoot them and not be prosecuted for murder. So the tribes came back out of the ashes following the 62 war roughly in the 1880s. Some remained in Minnesota and hid out. And then in the period of reorganization, the federal government acquired land bases for each of these Dakota communities. And so you don't see the 58 reserve. You see a dot because they really just have restored trust land rather than fixed reservation boundaries. Sorry. No.
Yeah, and well, okay. And so there are 11 federally recognized tribes in the state of Minnesota, and you got the ones up north and then the ones down south. And each of the 11 federally recognized tribes have established their own court and judicial system. And there's one more called the 1854 Treaty, or 1854 Authority. This is a unique court that enforces hunting and treaty rights, essentially hunting and fishing, gathering rights that are within the ceded territories, so the non-reservation territories throughout the United States. So it gives you a little picture of what some of these courtrooms look like. They are wonderful facilities. They're responsive, small. This is the contemporary form, of course. Different procedures are at play in each of these rooms. So each court has subject matter jurisdiction, and that subject matter jurisdiction is defined by each tribe's own body of law. So each tribe has its own body of law. Most, established a code that will govern that, and then each tribe is interpreting and applying their own unique body of law. 9 of the 11 tribes only exercise civil jurisdiction, and it's important to note that each of those 9 tribes still possess criminal jurisdiction, can exercise it, could exercise it, may exercise it. So despite PL 280, criminal jurisdiction is still present. 2 exercise civil and criminal jurisdiction. So Red Lake and Bois Forte each have criminal codes, and they are exercising their criminal authority alongside civil. 1854, talked about. Tribal courts are typically like the counterpart in the state, tiered with a district or trial level court, and then there's an appellate forum that litigants can bring their claims to or have a review of the district court decisions. In the PL 280 context, tribal courts play a very unique role in sentencing, criminal sentencing. So what 2 particular tribes in particular I'll focus on have established alternative courts that serve as diversionary courts for sentences handed down in state court. These are collaborative interjurisdictional approaches that have been established between the counties that are within tribal reservations or border tribal reservations. And so what you have is this, for example, we have a juvenile healing to wellness court. What you might see is a juvenile prosecuted by the state, because the state has criminal jurisdiction, sentence handed down, but because of an agreement that's been reached between the counties, the state, and the tribal courts, state judges will divert the sentence and assign a juvenile to the juvenile healing to wellness court. And then the juvenile healing to wellness court is then a product of the culture of the tribe and is uniquely tailored to stand in for probationary terms that would be typical under the state sentencing procedures. And that is if then a juvenile reaches and successfully completes the juvenile healing to wellness program, that satisfies the probationary terms. So if the sentence is stayed pending the conclusion of the program, then it's lifted and they don't serve out their sentence. There's a counterpart, there's an equivalent for DWI or DUI healing to wellness courts as well. And it's important to note that these wellness courts aren't specifically for tribal members. They are serving state citizens, non-Indians, non-tribal members as well, who are sentenced to the state system, but then diverted to the tribal program. This kind of interjurisdictional collaboration is something that, the reputation is that there is an adversarial relationship between state governments and tribal governments, and that very well may be in many ways, especially at the centralized level. But that breaks down on the ground with community members who are living together and working together and trying to ensure peaceful communities. And these programs provide immeasurable benefits to the state counterparts. Probationary services on the state side benefit tremendously. Money is saved, and while the state may be sentencing folks, the tribes really take on and earnestly deliver a service that restores and reduces recidivism, and it's been successful. In addition, in the civil context, there are all sorts of peacemaking circles or mediation programs that are available to tribal members to resolve their disputes without litigation. And maybe just sort of in closing, so we maybe have some time for questions, this is just a snapshot of what one court handled in 2013, and the kind of cases that they're hearing, and really the breadth of subject matter that these courts are delivering in terms of the services that they're providing. So you can see it's a lot of family family law is really central to what the courts are handling, but of course it goes beyond that, and this is not simply for tribal members. So I think that in terms of what tribal courts do and what role that a tribal court plays, it's absolutely central, of course, in the community that they're established, but it's essential to the wider community as well. And in terms of defining what PL 280 means and the limits of PL 280 jurisdiction, what's civil, what's criminal, tribal courts are very well situated to determine what the contours of that what the contours of that jurisdiction is. So I'll open up to questions now, just so we don't go over time, and so that what time is it?
53.
Okay. Other questions?
I have one online here. What are the implications of Title IV of the Civil Rights Act of 1968, specifically 26 U.S.C. 1326, requiring a special election for the state's acquisition of criminal and civil jurisdiction on the creation of mutual aid agreements in Minnesota pursuant to PL 280?
Well, that's a great one. It's easy to ask that question when it's coming from Online. I can't speak that specifically.
Well, I think that with respect to, I don't know about mutual aid and assistance agreements, but certainly with respect to intergovernmental law enforcement agreements, those really developed in a big way in the state of Minnesota following the Supreme Court's decision in State v. Stone, which determined that large chunks of the state traffic code were inapplicable in Indian country because they were civil in nature. They are civil in nature. That wasn't really good news to tribes. It was good news to the defendant in that case. And what that drove was a robust development of traffic law enforcement and generalized enhancement, that, at least in my experience, of tribal codes that governed things like traffic and commercial transactions and that sort of thing. But from a law enforcement perspective, what that then drove was a realization among the governments, especially the cops, about how's this going to work. That's the complex stuff, right? How is this going to work? How are you responding to a call? You're out on a highway. You're on the res. You're not sure if you have a tribal member or not. Are we going to have to call in the county counterparts if it turns out to be a non-member, vice versa? And so the natural solution was intergovernmental agreements, and several of the tribes have them. They were authorized by Minnesota statute and authorized by the tribes to essentially address that knitting of the distinct jurisdictions. Public Law 280 didn't have anything to do with extending state jurisdiction over tribal members for traffic offenses. That's what State v. Stone says. So, but it was figuring out where you're on a reservation. There's a lot of business activity on that reservation. There's a real mix of people. How do you help the cops be able to figure out who's who and what's what? And so, for example, Prairie Island has an intergovernmental law enforcement agreement. The Lower Sioux Indian community does. The Mille Lacs Band has a separate statute. And then, if I'm correct, I think that there is an omnibus intergovernmental law enforcement statute that allows any of the other tribes that want to enter into these agreements. It sets certain parameters that you have to have, whether you're going to be subject to state data practices laws, reserving immunity, talking about the role and responsibility of officers in the shared jurisdiction from a worker liability standpoint, and then also establishing tort claim insurance thresholds, or tort claim insurance coverage for departments when they are, for example, enforcing state law against non-members. So what the statute really authorized was not just, didn't authorize the intergovernmental agreements, but it authorized part of that intergovernmental agreement to be that tribal state licensed peace officers from a department that met these statutory criteria could enforce state law against non-members. And so that's what you see at Prairie Island, that's what you see at Lower Sioux, Mille Lacs, and elsewhere. So I'm not exactly sure about it.
Reading the question, I think I might just say that, so PL 280, its statute is divided. There's mandatory PL 280 states and permissive PL 280 states. Minnesota's mandatory PL 280 state, the conferral jurisdiction was mandatory, delegated, the state took it on. There are other states that were, had the option to assert jurisdiction with consent of the tribe, and that consent would be expressed through an election, a secretarial election, which is maybe what this person is asking. That's really not applicable in Minnesota because it's a mandatory PL 280 state. Now, in no circumstance would a tribal election be required for an interjurisdictional law enforcement agreement or any kind of cross-deputization between law enforcement officers.
Unless the tribal constitution required the council to secure an internal referendum before taking that action. But that's a matter of tribal law, that's for the council. Yes, sir.
Let me ask for your take on the perennial question. Is it time for tribal courts and state courts to give each other's judgments full faith and credit?
The question is, the perennial question asked is whether it's time for tribal courts and state courts to uniformly grant each other's orders full faith and credit. Yes.
Yes.
Please elaborate.
There is a real need, and the state of Minnesota and the tribe's judiciary have been very forward thinking and collaborative for years through the Tribal Court State Court Forum. They have worked on proposed rules. The issue is, do you establish a rule or a statute that provides uniform enforcement of orders as between jurisdictions, meaning the enforcing jurisdiction doesn't look behind the order other than whether it appears to have been afforded due process, so that you get seamless enforcement. Minnesota still functions on roughly the common law concept of comity, which allows for the enforcement of a brother or sister state or tribal jurisdiction order as a matter of respect and deference, but it is discretionary. And there is the common law of comity is well established in 8th Circuit precedent. There's some Minnesota precedent on it. But what judges on the ground on a Friday afternoon when a kid is on the run are praised with is it's discretionary. I speak to that because I've gotten the call at 5:30 when I've got a tribal member kid in Anoka and we have an emergency hearing and we get a nap and hold order and this kid is a danger to himself or others and we want to get him some help. And I spend the whole night trying to figure out how I'm going to get an Anoka County, and I'm not picking on Anoka County, I just mean an Anoka County Sheriff's deputy to feel comfortable enough that that order is good. And so the question gets to, in my view, especially with the development, we've got that with respect to OFPs, domestic violence orders, it needs to be uniform as between the jurisdictions. Getting to that is the work of many judges from the two jurisdictions. They've done great work, but we need your support in pushing that through, would be my answer.
How do two different tribes, members of tribes, sue each other, and how do they appeal?
That would depend on the situs of the case. Let's say maybe it's a contract case, and it would depend on the subject matter jurisdiction of the tribe, but as described in the code, if you have, for example, a contract dispute relating to some construction at a home on Mille Lacs, and it's a Mille Lacs member, and let's say it's a Fond du Lac member, and there's a dispute about construction defect, and it's on reservation, and the tribal court asserts jurisdiction, clearly has subject matter jurisdiction, and it defines its jurisdiction to, and this is very typical, to cover jurisdiction over all Indians, that you would then bring the case in Mille Lacs court. The appeal would be to the Mille Lacs appellate level. The non-member could challenge the assertion of personal jurisdiction, and that would be resolved within the Mille Lacs forum. Since it wouldn't be a non-member, you wouldn't trigger the federal question review jurisdiction in federal court.
I'm talking about two of the 11 tribes having a conflict.
Oh, if 2 of the 11 tribes have a conflict.
Yes.
You don't mean tribal members, you mean the tribal entities themselves.
Yes.
That would be...
It's similar to 2 states having a...
It would, and I am not familiar with a federal court case in which the dispute involved 2 tribes. 2 tribes clearly have been adverse as to a project, let's say a water project, whatever, and they can participate in those proceedings. But as to directly adverse to one another without a statutory abrogation of immunity or a waiver, I don't see that the federal court would have jurisdiction.
Okay.
Yeah.
I have one more online.
Sure. Just as long as it isn't that complex.
What is your opinion on the situation where online lenders issue loans to consumers outside tribal territory in terms of civil regulatory jurisdiction?
Online lending, online lending by tribes, often referred to as payday lending, raises issues that we also see come up in online, for example, proposals for online gambling, and that is, where does the transaction occur? And online lending can be done, well, let me back up. Department of Justice has gone after online lending through Operation Chokehold to make sure that these operations are in fact operated in Indian country, on Indian land. That really isn't any different than the question you deal with online gaming, and that is, where's the situs of the transaction? The transaction, in order to be immune from the civil regulatory jurisdiction, needs to be in Indian country. And so is the server processing the transaction, whether it's a loan or a bet, is that in Indian country? Or, you know, so it's the breadth of how you define that transaction. Is it where the bettor is sitting, where the bet is received and processed? Is it where the loan is initiated or applied for, or where it is processed and approved? Great question, and it gets to an area of the law that is very, very much in flux. The federal government is dealing with internet gaming, trying to get to that particular question, and has been for well over half a decade. And I think that the process for tribal lending falls in that same sort of concept of where does the transaction occur. And tribes that are doing it and currently are making certain that the operations themselves for processing the loan to the greatest extent possible are on Indian land. And that's without saying anything with respect to what I think about online lending, but that's how I think the structure works.
Thank you. Thank you.
Thanks.